I'm your host, Ms. Monique Hodge, your Corporate Communications Manager at the BVI Financial Services Commission. In this second quarter 2022 episode, we sit down with the colleagues from the AML CFT unit of the BVI Financial Services Commission who will simplify the topic of sanctions. What are sanctions? Why are they imposed? Join us as we discuss the prevalence of sanctions across the financial services industry, the range of financial restrictions, our capability to enforce them, and your compliance obligations within our jurisdiction. Welcome to all our viewers and industry stakeholders. I'm Monique Hodge, your Corporate Communications Manager at BVI Financial Services Commission. We believe that it is mutually beneficial for us to be a constant and direct source of information to avoid misinterpretation and unintended consequences. It is critical to the success of our relationship with you. Today our topic is sanctions and restrictive measures. Today we're going to have two very important colleagues with us today to speak about all the measures, the practices, all the aspects or advice that we need to give to our local clients and global clients from overseas territories and European sanctions law. So on our panel today, we have two very dear friends of mine. I've learned so much from them since working at the Commission. First, I'll introduce Mrs. Tracy Russ. She is the Senior Analyst in the AML unit. Part of Mrs. Russ's role as Senior Analyst is to coordinate the timely dissemination of sanctions notices. She assists in the internal vetting of sanctions listings and coordinates the responses to any queries or other related communication that we may have. Mrs. Russ has been with the Commission for over 14 years. I'd like to welcome Ms. Russ to the panel.
Thank you, Monique. I'm pleased to be here.
Also sitting on our panel today is Ms. Alva McCall. Alva is the Deputy Director of the AML CFT unit here at the Commission. Her focus in her role as Deputy Director is on developing and implementing the Commission's anti-money laundering and counter-terrorist financing supervisory strategy, and also enhancing the credibility of the Commission as the main AML supervisor. This includes the AML unit being the main point of contact for sanctions-related matters. She has been with the Commission for over 13 years. I'd like to welcome Ms. Alva to the panel.
Thank you, Monique. I'm really glad to be here.
Okay. First questions to Ms. Alva. First name basis here. We already talked about sanctions being restrictive measures, but tell us specifically the basics. What are sanctions and who imposes sanctions?
All right, so Monique, in the most basic terms, a sanction is really a penalty for disobeying a rule or a law. But in the context of what we're talking about, what we're hearing in the news recently, sanctions really apply pressure to countries that threaten peace or have harmful policies, or countries that don't cooperate with international law, like what we're seeing now with Russia and the Ukraine invasion. Okay. Right, so sanctions can be applied to individual people or to corporate entities. Now, in terms of who imposes sanctions, any country really can impose a sanction against another country, but in terms of the sanctions that we're hearing about in the news, there are really a few international agencies or countries that have been imposing sanctions that we need to be mindful of. So there's the United Nations, and they impose sanctions through the Security Councils. Then there's the United Kingdom, of course, who imposes sanctions through the Office of Financial Sanctions Implementation, or OFSI as we call it. And then the US imposes sanctions through their Office of Foreign Asset Control. And while those sanctions don't really apply to us, we still have to be mindful of them. Okay. And then, of course, there are European Union sanctions that are really part of the EU's common foreign and security policy.
Okay, thanks so much for that information. Then if we were to move on just a little bit more, I want to flip over to Tracy and then ask of Tracy, then in terms of the impositions, what types of sanctions can be imposed on us as it relates to our context? And then why do we have to adhere to the several sanctions that we hear coming out daily?
So trade sanctions might include the imposition of prohibitions on the transfer and the acquisition of technology and other non-financial services. Financial sanctions include asset freezes and other financial restrictions on persons who are designated on the sanctions list. A travel ban, for example, would also include restrictions on designated persons from entering into the UK, even for transiting purposes. They would be prohibited from doing that, and for all the UK-based territories. Yeah. So where persons have been designated on a travel ban within the UK, their travel privileges would be revoked, and they would have to be removed from the country. And the other type of travel ban include aircraft and shipping sanctions, which basically are prohibitions to deregister ships and aircrafts and detain them, preventing them from entering into the harbor or ports of entry in the UK.
So that's like seizing assets.
Not quite, because it depends on the nature of this. It's not really a seizure. So for example, if a ship is detained or they're on a designations list, maybe a country might not have the means to seize the ship necessarily, but they can certainly prevent them from entering their waters or ports of entry, thereby thereby alleviating them from breaching the sanctions. They might also put in notifications to alert other ships that this entity has been flagged that they are in breach of sanctions.
All right, so thanks, Tracy, for giving us that wide perspective on sanctions. It certainly helps us to understand what's happening in the world, why it's happening, and how it happens. I want to shift our attention a little bit more now back to Alva, and I want to speak about the overseas territory sanction orders. What exactly is that that Tracy just led us into? And then let's get into the legislative discussion. Where do they get that power? Where do these powers come from to enforce these sanctions?
Well, Monique, an overseas territories sanctions order is what we call imperial legislation. It's an order in council that's been handed down and prepared by the UK and issued to the overseas territories, right? These orders in council effectively become law in the OTs when they're issued and published, and they're required to be implemented by the overseas territories.
Okay, so what about the powers? Talk to me about the legislation.
Well, in terms of where they get their power, there are three layers of legislation. There's primary legislation, secondary legislation, and tertiary legislation. The orders are what we consider tertiary legislation, and they get their powers from the secondary legislation, which are the regulations. So the orders in council are made by way of regulations, and in the case of the Russian sanctions regime, those are made by the Russian Sanctions EU Exit Regulations 2019, and I think there have been some amendments to that. Now, the power to issue the regulations, those are granted by the primary legislation, which are what we call the acts.
Okay.
So in this instance, the regulations would have been made under the Sanctions and Anti-Money Laundering Act 2018, what's generally referred to as SAMLA. You'll hear people say SAMLA, that's what SAMLA is. And the regulations essentially provide for things like the freezing of funds and economic resources of certain individuals and entities or other bodies involved in sanctions activities, or entities or individuals who may be obtaining benefit from or supporting sanctions activities. For example, entities and individuals that are linked to Russia who may be involved in the destabilization of Ukraine. Mm-hmm. So those persons and entities and other bodies that have been identified and listed in the regulations, those are who we refer to as designated persons,
okay,
or generally you would hear people say this sanctions list.
Sanctions list.
Right.
So then that list must be something put together, names of those persons, their entities, their regimes, what they own and everything. I'm going to take this back over to Tracy, who would probably be able to tell me more about that sanctions list. What is that sanctions list?
So a sanctions list comprises the names of designated persons or entities whose business dealings and activities are the subject of the restrictive measures under the regulations.
Okay, so how often do these sanctions listings come out?
So in order to ensure that the licensees are aware of the sanctions listings, when the notification is received by the FSC and the FIA, those notifications are published on our respective websites, and this information is disseminated to all of the entities under the supervisory remit of both the FSC and the FIA. So these email notifications advise when designations have been made or delistings have been made, or that an amendment has been made to an existing designations notice or delisting notice. So in terms of how often these notices come out, it could be every day or every other day. There's always some notification that's issued by HM Treasury under the Office of Financial Sanctions Implementation. There's no set schedule for this. It's when these are handed down. But in terms of certain actions that the licensee is required to take when dealing with designated persons or entities that they suspect of being designated, I'll pass this on to Alva for her to elaborate further.
Thanks, Tracy. Well, licensees need to be able to check their client list against the sanctions lists when they come out in order to determine whether any of their clients or the directors or beneficial owners of their clients appear on these sanctions lists. Now, if there is a match, if they find someone on the sanctions list that is on their client list, then the licensee needs to be able to freeze any assets that they're holding on behalf for or on behalf of that client. And when we talk about freezing, it just means that they need to make sure that they don't allow any of those funds to become available to that client. The licensee is also required to file what they call a compliance reporting form, a CRF, with the Office of the Governor, because as you know, the Office of the Governor is the competent authority for sanctions in the territory. In addition, entities are also required to file a suspicious activity report, a SAR, with the FIA, where there's a suspected breach of any of the sanctions orders, or where a person, including a company, has conducted what we call a reportable transaction, where a designated person or entity has been delisted, as Tracy mentioned. Licensees should also ensure that any assets frozen are unfrozen, and that the delisted entity or person is removed from the licensee's list of sanctions entities. Now, delisting isn't something you hear about often, because when you hear the sanctions list come out, people tend to focus on persons who have been listed. But once the list comes out and it shows that an entity has been delisted, then the licensee has that obligation to ensure that that person, any restrictions that have been placed on that person is immediately removed. So they also need to notify the individual that their assets have been unfrozen. So there are other obligations that a licensee has in relation to sanctions. So Tracy will explain those.
Okay, so any entity wishing to deal with funds or economic resources for or on behalf of a designated person or BVI company or other entity where the beneficial owner is a designated person must apply for a license from the Office of the Governor to carry out such businesses. This includes payment of annual fees, legal fees, any other expenses. Before filing any transactions in relation to a sanctioned entity or persons with the Commission, including the Registry of Corporate Affairs. The licensee should ensure that it has obtained a license from the governor's office and provide evidence to the commission that they have this license, because the commission will not process any transactions related to a sanctioned entity unless they provide evidence that they have a license to conduct this business. So the procedures for licensing and the filing of reports are set out in the Virgin Islands Sanctions Guidelines, which are posted on the FSC's website.
So very good stuff so far. How does the commission, the question I want to ask is, how does the commission then take all this information and promote and measure the adherence to the sanctions obligations that are issued? Alva?
The Commission tries to ensure that its licensees are aware of their obligations through the publication and circulation of the sanctions notices, clearly, other written publications, and sessions like these. What we're doing here today is very important. I hope that persons find it useful and have a better understanding of the sanctions regime and what they are supposed to do by listening to us. But I mean, really, the primary means by which the Commission measures adherence is through our desk-based and the desk-based monitoring and our compliance inspection regime, right? This allows us to review our licensee systems and controls to ensure proper practices and procedures are in place in relation to record keeping, and as well as the performance of enhanced customer due diligence. And this is in order to prevent any sanctions breaches. Now, in relation to compliance inspections, they also look at a licensee's implementation of the sanctions guidelines that Tracy spoke about and the effectiveness of the way the licensees implement these guidelines.
Well, what happens if we find that licensees are not in compliance? Tracy?
So, under the Overseas Territory Sanctions Orders, breaches of sanctions carry a maximum penalty of up to 7 years, imprisonment on indictment, and on summary conviction to an imprisonment for a term not exceeding 6 months, or a maximum fine of UK £5,000 or the US dollar equivalent. So these criminal penalties may be separate and apart from other actions that may be taken specifically by the Commission under the relevant financial services legislation, including the anti-money laundering laws, the anti-money laundering regulations. For example, administrative penalties could be issued for breach of AML code and regulations. Okay. Separate and apart from the UK breach, the licensees also have to be mindful that they're adhering to the Financial Services Commission laws, and in particular, the AML CFT Code of Practice and regulations.
All right, lots of useful, helpful information for our industry practitioners so far about the topic sanctions. We've come to the end of this particular program. I'd like to turn it over to Alva now, Ms. Alva McCall, the head of our AML CFT unit. Are there any parting words that you'd like to leave us with or talk to our audience about?
Well, firstly, I'd just like to say, Monique, thank you for inviting Tracy and I to discuss this very important and very relevant topic. In terms of speaking to the licensees, I just want to remind them that they do have an obligation to make sure that they adhere to the sanctions regulations. So please check our website for updated sanctions lists. If you're not receiving the emails that come out to inform you that the lists have been updated, please contact us. You can send an email to aml@bvifsc.vg and ask to be added to the list. Please make sure you familiarize yourself with the Virgin Islands Sanctions Guidelines, which can be found on our website. Our website has a space specifically dedicated to sanctions matters that has a lot of good information on it. And just in general, we also have a space dedicated to regular AML issues that has a lot of good information from the Commission as well as the CFATF and FATF publications. So all in all, between those two spaces and the information provided today, we hope that it's been useful and that persons continue to adhere to the sanctions guidelines and sanctions requirements. Thanks, Monique.
You're welcome. Thank you so much, Alva. Thank you so much, Tracy, for joining us today on this platform. Thank you to our audience for listening to us. See you next time on FSC Direct. The Commission still believes that reliable and effective regulatory environment is paramount, and our consistent objective is to preside over a well-supervised regulatory regime that is fair, transparent, competitive, and attractive for legitimate business, and one that meets international scrutiny and our licensed community is compliant.